One of the trains that leaves is the accident investigation, but that's only one. A second one, obviously, is civil litigation. Civil litigation starts essentially the day the accident occurs. It used to be that lawyers couldn't advertise. And when lawyers couldn't advertise, after an accident, what would happen if there were 100 people on board the airplane? You would have 5 law firms that specialized in aviation accident litigation representing all 100 people on the airplane and their families. Once lawyers were able to advertise, everything flipped around. Now you have 20 or 30 law firms representing those same 100 families or passengers. Now, how do they get those? They solicit them. Horrors, you mean lawyers solicit? The solicitation became so bad that the Congress passed the Family Assistance Act, which said lawyers cannot solicit the cases for 60 days, and insurance companies cannot speak to the families for 60 days. But the fact is, the solicitation starts. It may not be as gross, it may not be as open, it may not be as above the board, it may not be as visible, but it starts. The civil litigation starts almost immediately. And frequently you will have lawsuits filed almost immediately. Why? Because it's the right thing to do? Because somebody wants justice? No, because the first one that files a lawsuit gets the most publicity. And if you get publicity as a lawyer, you'll get more cases. That's a very cynical view of the whole thing, but it's also the truth. So the second train that leaves the station is the civil litigation. Everything that is developed, every word out of an airline employee's mouth during an accident investigation, every document that is turned over by an airline during an accident investigation is usable in the civil litigation against the airline. So one of the things I will always tell our clients prior to an accident ever occurring is don't ever permit your employees to be interviewed until they've been fully prepared by the lawyers and they are represented at the interview by the NTSB investigators by a lawyer. Don't ever turn over original documents to the NTSB, and if they insist, ask for a receipt. Why? Because the NTSB may lose them. Learn when to say no and learn how to say no. Because as a natural consequence of an accident and as the natural consequence of being in a service business, an airline doesn't want to say no. An airline wants to cooperate and get through the exercise. And without having bearings in terms of having been involved in something like this before, God forbid, the more guidance an airline can get, the better off they're going to be and the better served they're going to be in the larger scheme of things. So you have the NTSB, you have the civil litigation. You also these days have criminal investigations. District attorneys who are typically elected at a state or local level, United States attorneys who are appointed essentially by their senators, although nominally by the president, are all looking for the next step of their career, whether it's an elected office or an appointed office. Frequently, you will have criminal investigations. Virtually never do those criminal investigations go anywhere. But at the end of the day, what happens is there's an announcement by a district attorney that a grand jury has been convened to look into the maintenance practices of the airline. 6, 8, 10, 12 months later, there'll be a story on page 17 of the newspaper saying that there'll be no prosecutions, but the damage has been done. Because there's been a grand jury, there have been witnesses pulled in from the airline, and so forth and so on. And everything that is developed during the accident investigation is usable in the criminal proceedings. So the third train that leaves the station is the criminal proceeding. The fourth one that leaves is the FAA. The FAA has this dual role. On the one hand, they're investigating the accident. On the other hand, they are investigating you. And the reason they're investigating you as an airline is that they hold your certificate. And the certificate holding office is going to determine whether or not that certificate was in any way violated by way of the FARs. And at the same time, that certificate holding office is protecting themselves because they're looking over their shoulder at the DOT Inspector General, who is going to be looking to see if that FSDO was too close to that airline. And in fact, as you all know, recently there have been rules implemented saying that inspectors who have worked in certificate holding offices and they leave the FAA, they cannot go to work for airlines over whom they had control or whose certificates they held for a fixed, I believe it's 2 years. The situation got so bad they actually had to impose those sorts of rules in terms of appearances. So you have a civil penalty investigation. Now let me tell you, let me suggest to you something. The truth is, whether you know or not that the feds or the state prosecutors are looking at the accident, trust me, they are. Whether you know it or not, if you don't think the FAA is looking at letters of investigation and proposed civil penalties, trust me, they are. Whether it reaches that point or not, they're looking at it. And more often than not, one or more of those are going to actually take place. Another train that leaves in every piece of evidence, every document that is developed, turned over, used, every statement by your employees, including at the public hearing where it's sworn testimony under oath before the NTSB, is usable in every one of these other proceedings. You have your own employees. Your employees fall into two bodies here. One is the people who are on the airplane, their families. Frequently, they do not get the same level of public attention as the passengers' families do. But you have the families of the crew members or the surviving crew members. They have to be dealt with very specifically, very specially. In addition, you have the rest of your employees. They need information. They're asking questions, and more importantly, they're being asked questions. You have your unions, as I said. The unions can be a problem. And those of you who've dealt in this area, you understand what I'm saying. The union mandate is to protect their constituency, which is the union member. And if you put that in the context of the pilot, it's typically from a union perspective, or all too often from a union perspective, the fact that the company didn't properly train that pilot, or alternatively, the company didn't give that pilot the proper procedures. But it certainly is not the pilot having made a mistake. So says the union, which would seem to put the union at odds with the company in the context of the accident investigation. But remember, everything that's developed and everything that everybody says during the accident investigation is usable in the litigation. So what you have, not conceivably, but actually, is you have company employees who are acting on behalf of the union in the context of the investigation, saying bad things about the company that are going to be usable in the litigation and in other proceedings with respect to those various tracks that actually, as I hope you can see, really do start to cross one another at various points. You have the media, which is voracious, 24 hours a day. Aviation accidents obviously provide great fodder to that 24-hour machine. They have to be dealt with. But what can you say and what can't you say? The NTSB makes it very clear you can't say anything after an accident that you couldn't say before the accident. If there is any question in your mind in terms of how serious the NTSB takes that, think about the helicopter midair that recently took place over New York. The Air Traffic Controllers Union didn't know when to keep their mouths shut during the investigation. As a result of which, after one warning, and having done it a second time, the NTSB threw them out of the investigation. Because remember what I said at the outset, everybody but the FAA participates in the investigation at the sufferance of the NTSB. And if you abuse that, they will throw you out of the investigation, and then you are up the creek. Because the investigation train is going to move forward, and you will no longer have party status. You will no longer have any say, any input, any control, any ability to direct how this whole process proceeds. So the media guidelines are something that really have to be dealt with before the accident ever occurs, in terms of the people who are going to speak understanding what they can and can't say.